demonstrable only in the order that the authority makes. My humble and respectful service, that's the correct view, Manus. We are not playing Manus games here. For the order to demonstrate application of mind, it must contain the reasons. So your lordship goes further. First is what is on the order, not what is in my almirah. Second is the reasons in that. As recording of reason and order is the only way that can construe such application of mind. Then your lordship gives this very felicity. That's why I quoted the Supreme Court first. Reasons are the links between the mind of decision taker to the controversy and the decision arrived at. Ratiocination, I call it.
Yes.
Reason and application are impregnable. That's a new word, Malas. Ratiocination, impregnable. No, because this is important, Malas. This is how administrative law is built up.
It is inseparable.
Public law builds up like this only, Malas.
It is inseparable.
For an order to sustain the scrutiny of law, be it administrative or quasi, reasons in every circumstance need not be elaborate, no problem. Nevertheless, should bear application of mind. The case at hand and the order impugned will have to be tested on the anvil of the mandatory statute, the intent and the rule of application of mind. If on a coalesce of all the facts that are narrated herein above and the order that is impugned on the anvil of this object and reasons, it would fall foul of the same as the order. Now, let's kindly bear with me here. As the order, except saying there is nothing indicative of the fact that it bears application of mind. Granting approval for setting the criminal law in motion cannot be a frolicsome act as is done by the state in the case at hand, as it does not even bear any semblance of application of mind. As this frolicsome should also be adopted by some other courts.
Playful act.
I go for my frolic of my own. This used to be used in those public servant cases where it's within the discharge of your duty. So he used to say that in the English cases, he went on a frolic of his own. So
that's the...
Now, I just pause here. My case is actually in a way a better example against them. In a way, it sounds like a better example against me, but no. Your lordship, this case had possibly no reasons. I'm not examining the order.
No reasons at all.
In my case, there are all reasons, but for one issue only. And equally for the other issues, zero reasons.
It contained only those words, checked and found correct.
Checked and found correct. My case is the same for the issue which it had to address is my submission.
No, there are reasons. It's not that it is...
For the issue it had to address. Malus, I can write a 100-page order.
But it is not a case where it does not bear even a semblance of reason.
No, Malus,
but it is.
That is actually, my lord is absolutely right. Malus, an order which has to address Y, writes 100 pages for X and doesn't address Y. It can't fool a court, Malus. It can fool an ordinary person.
That is Wednesbury, taking irrelevant consideration.
I'm saying the 100 pages is valid and relevant, let me assume. But Malas, that is deciding issue A. Today the argument is on issue B. I will be reading the order. Your lordships cannot find a single word on issue B. It's the same case as your lordships. This one, Shirupa. The difference is that you wrote 6 pages on an issue which takes you neither here nor there because it doesn't give you the reason why I am to be sanctioned. But on the issue of why I am to be sanctioned, which is issue B, there is 0. And this was 0 also. In fact, this was more, but I said corrected and found. The governor didn't say that also about me.
That was a case of that kind.
Now verse 21. The impugned order does not demonstrate any reason, I am applying it to my case, any reasoned application, especially to the core and crucial aspect. This is the aspect on which there is 0. Kindly see the aspect of how, why, in what manner is there any connection of the petitioner, much less prima facie culpability, with any decision, recommendation, act or event justifying the grant of prior approval. Not a word. It regards the constitution of a committee under an IAS officer and a commission of a retired judge as an acceptance that there is a big ticket scam and does not inspire much confidence. So it uses the other 2 things. I'm dealing with every reason that is there. There's no other reason. It says that because the commission inquiry is made, that is proof of a big ticket scam, therefore I must give sanction. It doesn't deal with one question my lord put in the hearing also, because I heard it, I was here. My learned friend didn't answer it. How is this petitioner involved?
That is...
No, that's only a question. I mean, your lordship putting questions to me also. I'm just saying, well, this is the heart of the matter. This is despite the fact that by his own earlier letters of 5th of July and 15th of July, the governor himself had drawn the attention of the chief secretary Now, this is very interesting, Wallace. He says, I have read of a commission of inquiry set up by you that itself makes it clear that there is a scam and therefore I give sanction. See the next sentence. The same governor on 5th of July and 15th of July drew the attention of the chief secretary to the matter of alleged site allotment scam at MUDA and requested the government to look into the matter and submit a detailed report. Just pause. Suppose the chief secretary had said, sorry, Mr. Governor, I will not have a report to you because you will use the report as an admission of somebody's guilt. Suppose the chief secretary had said so. The chief secretary would have a huge controversy on his hands. So as he has an inquiry, that inquiry becomes the noose around the neck to say, I am now finding culpability. But in both the actions of the chief secretary and the governor, there is no mention of the chief minister role. CM's role, zero. This is despite the fact that, I'm sorry, it states that even after such grave allegations being involved in the present matter, and the fact that the materials prima facie support, therefore, now this is the total reason. What is the reason? I'll find here, Wallace. This is the total reason. Please read it for yourself, Wallace. 21.2. Even after such grave allegations being involved, so allegations become a basis of conclusion. And the fact prima facie supports the allegation, therefore the decision taken is irrational. Here again, Wallace, he is not giving you any single reason. And most important, the role of my client, the petitioner. I'm myself putting everything which is there against me. The said statement is entirely unreasoned and opaque, especially since all material is fully considered. Then 21.3. The order further says that since the prior approval is sought against the chief minister in the cabinet resolution, therefore it would not inspire confidence to act on the aid and advice. In support of this view, the governor refers to para 32. Now, I have done this fully. Leave it to yourself, your lordship's well to consider, is it a fair understanding of MP? The nuance which I have pointed out, the meaning of 32, nothing else. Finally, the governor notes that there are two versions in relation to the same facts and therefore a neutral, objective and non-partisan investigation. This is very interesting. The two versions test is plainly an insufficient basis on which to disregard the aid and advice of the cabinet. As in every case where the cabinet declines prior approval, there would necessarily be two versions, as my lord rightly put it, 3, 4 or 5 versions also. Truth has many facets.
Of course.
That is the old saying. What is that Sanskrit saying? Forgetting. It's in Hinduism especially, we say that the path to truth. In other religions, maybe one or two, but we have multiple paths to truth. So therefore, bhakti yoga or karma yoga.
Yes, yes.
So the truth must have many facets. Here are talking only of two facets. It was for the governor to point out some manifest irrationality in the version as outlined by the cabinet failed to do. Instead, he treated the complainant's version, a complainant of dubious antecedents, as at par with the considered view of the cabinet after seeking opinion of the advocate general and decided there were two versions. A neutral inquiry or investigation was called for. This supplies the fallacious test of why not the correct test of why.
Yes.
And if your lordship takes this test, then there is no reason required at all. Further, it is evident from the written submissions filed by the R2 that the decision of 1-8 was placed before the governor on 6th of August. Now, kindly see this fellow's sequence in para 22. The governor asked that it be put up before him along with the comparative statements, the chief minister's reply and the cabinet decision. It is then stated that upon reviewing the file along with such comparative statements, certain notes, analysis and points were dictated. I'll put that dictated in inverted commas based on the comparative statement in the documents. On 16th of August, the file was once again put up before the governor along with the dictated notes. It is at that stage that the governor made the impugned order. It is relevant. Now, this is one of the bullets. None of the materials placed in this para so-and-so have been placed on record by way of an affidavit. More important. Further and most significantly, if there were notes or analysis points that had been dictated by the governor, it is inexplicable why such analysis would be excluded from the impugned order. Well, my 22.2, I may be wrong, is my most important para on this topic. 22.2. Well, it is never, you dictate a long order in the file and you pass a 6-page order on bias only. Moreover and crucially, while the written submission of the respondent rely heavily on the file notings culminating in the impugned order, The impugned order itself makes no reference to such file notings or the comparative charts, tables, or the notes and analysis which have been dictated and with which the file had again been put up for the governor's approval. If these were indeed the factors that had weighed with the governor would certainly have said that in view of what is set out at flag X or flag Y of the file, it should be Y, not X. He accords sanction, approval. Thus, this is not a case where the impugned order of the governor endorses, accepts, or engrafts into itself a previous file noting. Where the order itself does not do so, it is not open to the respondent to portray the decision as if it is based on such notings. The impugned order refers to the governor having perused the file and to the allegations and having independently submitted report to the same. There is no reference of the charts or the notes or the analysis in the file. The petitioner had submitted a detailed reply, that is my reply, on 3rd of August, raising several legal and factual issues for the consideration of the governor. Apart from meeting point by point the allegations made against me, however, there is not even a whisper with regard to my reply and its consideration, either in the impugned order or in the file notings. The impugned order does not assign a single reason as to why the prior approval is being granted. No reasons as to why the detailed reply is not being accepted. No reasons as to how the petition, complaint, allegations make out a prima facie case against me. Very importantly, no reasons as to what role of the petitioner, while acting as a public servant in discharge of his duties at any stage, in the detailed factual background, is made known either in the impugned order, the file notings, or in the statement of objects or during the course of arguments. This goes to the root of the matter. Then was 22.5, reasons ought to have been assigned, etc. Both the paragon reasons. Now, I'm just dealing with three aspects of 17A, which is that number one aspect is that your lordships does not equate it to Lalita Kumari. Second aspect is the police officer being the first filter.
Yes.
And third aspect is the impugned order is ultra vires 17A also and 218 also. So these three aspects I am now dealing with.
218 comes at a later stage.
Later stage. Correct. Now kindly come to this. Two and 8 was largely conceded, but I'll just deal with it. I'll come later. Just come to 32 minutes.
Page 32?
Yes, page 32, para 23. The power to grant previous approval is not to be exercised in a manner analogous to the test for registration of an FIR. The submissions proceed on the fundamental erroneous premise that the principles set out in Lalita are relevant for ascertaining the scope of the inquiry. The analogy seeks to draw between registration of an FIR and a grant of approval to inquire or investigate is misdirected, also oblivious of the legislative history behind the introduction. Now, this I am not going to go in detail, but I must let your lordship know that the intent could not have been a FIR level inquiry. That's all. I'm just giving your lordship, if whatever is worth is not dealt with by any judgment, it may help your lordship.
In fact, the genesis of why this amendment had to come about sprang only from Lalita Kumari in 2014. The first law commission, I think, is in 2014.
Well, I've dealt with part of that.
And then it took 4 years to come about. Because approval was sought to be given to the hands of Lokpal and Lokayukta for approval.
And that was a much higher scrutiny. Only the person was changed.
Competent authority comes in.
That's all. But the degree, that's my core point. The degree was not reduced is my submission. That's the only point. Your lordship summarize it now. The initial idea was a proper filter and safeguard. That remained the idea. The power was taken from him and given to me.
Yes, it was initially envisaged to be given to Lokayukta or Lokpal.
He is the Lokayukta, I am the authority. It came
now
to
it
me.
Is to the competent authority.
But in that process of transfer from him to me, the diminishing of the power to the extent it did not happen.
No, the provision remained the same, or the idea remained the same. So it is only the person who grants approval.
I am very grateful. Changed. That's the crux of my submission. The idea is my point.
Whatever protective
idea remained the same.
Protective filter that was envisaged in 2014 remained the same.
And the degree and quantum of that remained the same. The person exercising it changed.
It took 4 years to come into this form.
That because of all these committees and back and forth. Well, there's a delightful phrase for committees, one is a WAG. Your lordship, pardon me. It is not meant for any committee. But a WAG generally commented that a committee is usually a group of the unfit, appointed by the unwilling to do the unnecessary. So these delays happen because you want to also take off the time. Well, it's 24.1. The Prevention of Corruption Amendment Bill was introduced, did not contain any 17A. Then 24.2. It was first considered by the Rajya Sabha Standing Committee in its 69th report.
No, all that I'll go through.
Then,
Sorry.
well, I'm not reading it.
Yes,
Then it was brought in 24.3. Then that bill went to the Law Commission
yes.
in February 2015. Now, this just see the middle, Malas.
Hmm.
It is clear that the previous approval will be granted by Lokpal or Lokayukt and would be conveyed by an order under Chapter 7. Now, this Chapter 7 outlines the procedure for a robust and elaborate procedure, including calling for explanation. Therefore, from a mere perusal, it is clear that it is my submission. From very inception, the amendment proposing 17A as an additional entry checkpoint protective filter, was contemplated as substantive protection and nowhere close to the standard for registration of FIR. That's my proposition, that's my Lordship's consideration. Then went to select committee, skip that, come to 25. No, I'm sorry, 24.5 is very important. I'm very sorry. The select committee proposed a further amendment where the power to grant approval was given to the appropriate government and not to the Lokpal. Thus, a change was made as to who would exercise this power. But it is clear the intent was always that the protective filter would be a substantive protection. But also, it's very clear, Manoj, I happened to chair this committee in 2011 when the Lokpal bill was passed. We piloted the Lokpal bill.
Yes.
Now, the Lokpal delay is inevitable. That was the main reason for this transfer actually.
Yes, yes.
Because
the
the Lordship
competent
give it to the Lokpal and give it to a competent authority is a vast difference of time. That's all. It is not that you are making the power less. It is just that you make it faster. That's really the bottom line thing. But anyway, this unfortunately not decided by any case. Then Malus, Shirupa at page 34. However,
That's a coordinate bench judgment where 17 and 19 are considered differently, and it is said that 17 need not bear that much of an application of mind like 19. That's a
Right.
coordinate bench judgment.
right.
Yes.
So therefore, Malus,
Which distinguishes the judgment that I had rendered.
but Malus, I am relying on a Lordship's judgment. I am
Yes,
not
yes.
distinguishing it.
Yes.
I am adding to it with
Yes.
this para and underlining what I'm relying on this one also.
Yes.
I have no contradiction in my mind. They have the ones who argued, may have argued differently. But they thought that Shirupa is against me. I demonstrated that part of Shirupa, Lordship's judgment. Now, this one, just see what I'm relying on.
Yes.
Middle of page 34. In a sense, a public servant is placed on a pedestal and treated differently as compared to a citizen against whom an allegation of an offense is thrown. The law thus grants an extraordinary layer of protection.
Hmm.
This is the idea.
Yes.
Then 35. I'm not trying to avoid anything. I've quoted it, but I'm just reading
Yes,
faster
yes.
too. Has some credible evidence on the basis of which he forms an opinion that an investigation is warranted. Who is he, Malas? This he here is the police officer. This he at 35, credible evidence on the basis of which he forms an opinion that an investigation is warranted.
Police officer is what you are trying to say. Yes.
Then, Malas. No, the whole para, just give me a minute. Let's come to para 30 at page 34 bottom.
Yes.
It is therefore not necessary there should be a clear incriminating evidence with the IO.
At the stage of him seeking
At the
approval
stage of him
under
seeking
17.
prior, all that is required in the provision of the Act is that the IO has some credible evidence on the basis of which he forms an opinion. This part is clearly IO, Manas. He gives me the information, I am the IO, I form an opinion, then I seek approval. There are 4 steps or 3 steps. Information, formation of opinion, seeking of approval. As a consequence, the state government would be required to only consider the opinion that is formed by the investigating officer. Why is the Lordship saying all this? And the material that he possesses while considering the request for approval. Since the public servant is yet to be investigated, the question of considering an India, I'll skip that. 34, next para. It is also clear from the wording of section 17A. The state government is not required to exhaustively and meticulously consider all the material available with the investigating officer at the time he seeks approval. It is only required to
This is where it is different from what I have said.
Correct.
It need not apply its mind is what is said here.
Well, it's, I see the difference in emphasis, but I don't think it would be right to say that your Lordships is wrong in saying application of mind. That would be, well, say, something which will possibly not stand the test of law, is my submission. And this, even though it's worded differently, should not be read to mean that application of mind is so diminished as to be a formal administrative entry in the register.
Yes, that is true.
That is the way I would look at it. Because according to me, 17A is somewhere between 19, etc. and Lalita Kumari. That is the correct way to look at it. Please don't reduce it to just a Lalita Kumari level. Please don't elevate it to a 19 level.
Yes.
Because that's a fair way of looking at it. Otherwise, Manoj, why have all these select committees, parliamentary standing committees, law commission? I mean, was it the intention, Manoj, to make this kind of a provision? You already had Lalita Kumari. It would have taken 2 sentences to say we apply the Supreme Court has Lalita Kumari. We are doing this. Manoj, your lordships is being asked to dilute it to a level which is not fair on the legislative history of 17A. It is not borne out, certainly not by my Lord's judgment, but also not by this judgment, which should be read in harmony with the Lordship judgment, instead of deliberately saying we must drive a coach and four between the two.
No, because para 34, if you see at page 35,
Yes, sir.
that is what is not required to exhaustively metically consider all material available within
It is put in that
at the
way.
time of seeking approval.
And it is only required to examine and consider the opinion formed. Now, I would, if that is the argument of the other side, I would say maybe when he gives it to approval, he may not put everything. But in his own formation of opinion, the lordship tests remain. If I am the IO, my formation of opinion must bear a full application of mind. Maybe, Manoj, when I reproduce it for approval, this judgment can be read otherwise. Then just come to 36, Manoj.
Yes. 36 itself, para 36 at 36.
The grant of sanction to prosecute and the grant of approval to investigate are two very different concepts and would be governed by completely different parameters. At the stage of seeking sanction to prosecute, the IO would have completed the investigation, would also have collected material which his opinion would prove that the public servant is guilty of the offence alleged against him. In other words, at the stage of seeking sanction to prosecute, the IO is well armed and certain that there is material to establish the guilt. In respect of according an approval to investigate, obviously the situation will be completely different. Since at that juncture, the IO would not normally have any incriminating material, only possess credible information about the commission of an offence. It is this credible information that is required to be considered and analyzed by the government. It is thus clear that the parameters that govern the according of approval should be completely different, and the government would have a much wider discretion while considering the request of the IO. I am on a different point, Bharat. I am not on this point. I am not on this perceived collision between your lordship's wording and this wording. I am on a totally different point. Who is all this? It is not a direct lateral entry by somebody without the police officer IO, whether he does this much application of mind or this much. It is he who does it. Not a lateral entry was bypassing him or overriding him. That's my argument. Page 37, para 46. Law except there be different standards for granting approval to investigate or granting of a sanction, one cannot be equated with the other. To put it differently, the parameters that are to be applied to investigate a public servant are not as stringent as the parameters which provide for granting sanction.
This is what is,
No, that's true.
the application of mind varies from 17 to 19.
Let us, for my purposes, accept that.
Yes.
I am saying, Malaj, don't reduce it to the vanishing point of Lalita Kumari. Don't elevate it to that side.
19.
And secondly, it still has the police officer. This lateral entry I am not agreeing to. I am trying to build up that argument. That's the second part of my argument. Just come to the bottom.
So it is only the police officer who can seek approval.
Start this whole thing. Because Malaj, he's supposed to be the custodian, sorry.
All right.
And without a statutory custodian, it is not that Malaj, he's the best custodian, but he's a statutory custodian, he's a persona designata.
Now in a private complaint, how will it work?
It must go through this first.
No. How can it go? They go to the police first.
Yes. No, because it's not the private complaint who determines this.
No, no, no.
It will
Straight away
determine-
200 will not spring.
Yes.
154.1, they will go to a police station. Jurisdictional police, they will not register. Then a higher officer under 154.3. Then they approach 200. In 200, where is the police officer unless it is referred to investigation?
Now, Malaj, two things. The number one answer. The test is based not on private or public complaint. The test is based who's the accused. That's
No, no,
one way.
Accused may be anybody.
No, public servant.
Of course, if it is Prevention of Corruption Act, 17A comes only because it is public servant.
So first and foremost, this is a safeguard for a limited class of people.
True, it is public servant. Now, in this functioning, the police station, yes, police officer should seek approval, no doubt about it. In a private complaint where police officer is not involved, Police officer comes into picture only when 156(3) or 175 reference happens. Reference happens for what? For registration of a crime. If registration of crime already happens, where is the question of approval?
There, Balus,
That is why that
there, Balus, either
the police officer only should seek is a little
I
difficult to.
understand, but there, if that is the case in a private, but then the private complaint example can't take over all the non-private complaint cases. That's answer number one.
No.
The Lordship will not read it
In a non-private complaint, obviously it will happen by a police officer.
No, but then your
Approval will be
Lordship,
sought by a police
then
officer.
your Lordship, even in that category, is giving the possibility that it can be a somebody else altogether. That can't be the law. But second answer, Balus, then in that case, the magistrate will have to iron out the problem.
No. That is why in that judgment, what I wrote was, in a private complaint, you are taking away the 17A approval and directly getting the crime registered. That protective filter goes away. It is rendered ocious or rendered redundant.
Yes.
For that reason, whoever approaches the magistrate who would wanting to register a crime against a public servant, it is his responsibility to get an approval. Without the approval, the crime cannot, no reference can be made under 156(3) is what I have said. Their police officer comes only after 156(3).
What my Lord is saying is that
How do you harmonize the two now?
my Lord is right. The Act has not thought of this problem. They should have. But Balus, 156(3), should it not be coming after 17A stage, Balus?
Yes, that is what I have written. That is exactly what I have written.
No, Balus,
Kindly consider this. If this interpretation is given, will the protection given under 17A still continue to be available to a public servant? If you allow anybody and everybody to walk in and seek protection?
No. That is exactly why 17A is made applicable to private complaints also. See, now imagine a hypothetical circumstance that 17A, one complaint is registered before the Lokayukta. The Lokayukta police will seek approval of the competent authority under 17A and try to invest and register FIR, begin investigation. Now that procedure will be obviated. Ultimately, what the complainants would want, registration of a crime against a public servant. Now 17A is a bar. If private complaint as a stranger or citizen, any criminal law can be set into motion by anybody. So they go before the magistrate, register a complaint under under section 200 for various offences, including PC Act. Now straight away reference is made for it is referred to the Lokayukta, FIR is registered, investigation commences. Where is 17A? The very purpose of 17A is lost. That is the reason private complaint also.
the other, this is of course, Balus, there's a, if I may say, the casus omissus possibly in the Act also.
Casus omissus, yes.
That's not your Lordship's problem. That's not my problem. That's
Yes,
the
that is the legislature. That's the.
Well, is it possible to say that the 156(3) must come and then you go through 17A after that? Because 156(3) brings in the magistrate and then well as the private complaint goes on. But then before you proceed further, the 17A approval comes. That's another way of looking at it. I'm just thinking.
That can also be done. But prior to beginning of investigation against a public servant, 17A compliance is mandatory. That is what exactly I've said. Because what used to happen in so many cases is, they don't go before the Lokayukta, they don't go before the police.
You go
Straight away register a private complaint. And once it is referred for investigation, the police have no jurisdiction except to register the crime.
Nullifying 17A.
So defying 17A.
Fact, question of locus did not arise either in Dr.
No, locus is alien to criminal law, sir. A locus to apply, locus to apply is,
Either in Dr.
No. Locus to apply would, locus would become applicable to the person who wants the complaint to be registered. Now the police officer wants to investigate, he will seek, that is under the Act. Now the complainant wants a private complaint to be registered against a public servant for offences under the PC Act, he will seek.
So there is a problem. The only thing I can think of is that there is a 156(3) going to the magistrate and some procedure of 17A follows that. That's one way of looking at it, Balus, but
We'll see, we'll try to harmonize in this case.
anyway, your Lordship is good, Balus, because
Yes.
if 156(3) goes first and 17A follows, your Lordship is having fidelity to both. That's what I was just trying to think out. But there may be some other problem I'm not able to think out immediately. Whereas
No, why I wrote that order was I'm trying to, otherwise 17A becomes.
the Lordship may consider this, that your Lordships should preserve the primary filter of the police officer. One way of preserving it is to have the 17A cases in a private complaint go through the filter, of course, as it does through a 156.3, followed by the requirement to get a 17A.
Well, accept that. Now, in a given case, 17A approval will be sought. For what? It may not proceed further.
No, but your Lordship is only concerned with the approval being sought and going through a police officer's filter. It
That's
may not
what,
be
whether
given
it is the
except when
police officer or the person who sets the criminal law into motion.
Well, it can be with 156.3, there is some greater harmony as I see it here. Well, any magistrate may order an investigation in
Yes.
156.3.
Order an investigation.
But if 17 has to have meaning, then why
No,
can't?
now against a public servant also, a magistrate can order investigation.
But then, exactly. But then, because he's a public servant,
17A should be there.
exactly.
That's exactly what I've written.
But after the entry of 156.3,
29.5.
I have tried to answer it somewhere lower down, but let me just read through it. These are only two answers. The harmony can be that your Lordship does not render a 17A to be
No,
diluted.
the language in 17A is no police officer shall commence inquiry or investigation. Fair enough.
All three covered. All three are covered.
All three, no problem. No police officer can commence without prior approval under this provision by the competent authority.
Technical sense, the magistrate.
Who seeks the approval is not there in the statute.
That is a separate matter. Whether locus is not there, criminal law has locus or not, all that is separate. My point is, whoever it is, let's say assume a stranger is there. Your Lordship gives a definitive role to the police officer. The first port of call is a magistrate who is not a police officer. He initiates or allows their filter of 156.3. The second port of call must be a 17A police officer. And then, that man, if we say no,
Now
then the locus ends. That
Now 156.3, magistrate refers. Will the police officer who has been directed to conduct investigation wait for an approval from the competent authority?
No, that's then the answer is clear. Once your Lordship accepts that, answer is yes, he has to. Otherwise,
that
what's
is
the point
why-
of having 17A? Then
That is why, to obviate that procedure of once referring the matter for investigation and registering the crime, so taking 17A approval for conduct of investigation. If a prior approval is already there, magistrate will refer it and the investigation will commence immediately.
that will,
That is what.
I understand. Your
Yes.
Lordship may consider harmonizing in this way because that means that the primary port of call of the police officer is ended or diluted. That is my problem. I'm trying to harmonize that part. In this other model I am giving a Lordship, which is not fully thought out, maybe I can give a supplementary one-page note after thinking it out. It appears prima facie that your Lordship does not violate any of the provisions of the statute.
That's
Because
all.
the outsider chap, goes to the magistrate, he gets some order.
Yes.
Then, it must fully satisfy the police officer who will say no. That's the end of the story as far as he's concerned with that point.
No, he has no jurisdiction to say no once the magistrate refers the matter for investigation. The investigating agency cannot say, I will not investigate.
That's the point.
That is why that protective layer should
Right,
spring
no, my lord,
prior
right.
to the complaint.
Therefore, your Lordship judgment will have to say that the 156.3 order cannot violate a 17A order. Your Lordship will have to say that a 156.3 order must then thereafter
Cannot violate a 17A order.
No, not
True.
cannot violate. Must not override the 17A order coming later. The 153 will say, I am referring it, but this part will be done first, 17A. PC Act. Because this was, in fact, the more
PC
we
Act, of
discuss
course,
it,
yes.
it's becoming partly clearer. Your Lordship is having a limited class. It is not except outside the PC Act and public servant. For that limited class, suppose the magistrate says, he will not say it generally, he will only say it under your Lordship's orders. Otherwise, High Court has to lay down the law. That, look, I am issuing a direction, I'm initiating this investigation, but where 17A is required, it will proceed further only after 17A is given or not given.
So now magistrate refers under 156.3.
But then comes
The
17A.
jurisdictional police or the locator at whom it is referred, he may have to wait for 2 months, 3 months for approval and then begin.
That is one way of looking at it.
And then begin. Is it not that if the approval is already there and a private complaint is preferred. Reference be made prior to approval is not a better circumstance.
Then your lordship is bypass the police
No,
officers.
we are only permitting police officer only to investigate. Nobody else is investigating. The after reference, only the jurisdictional police or the lokaयुkta will investigate. But he will investigate only after the approval is there under 17.
I understand. There's a slight issue there. Initiation is not by the police officer in your lordship's formulation.
Yes.
Initiation is by the police officer under the magistrate rule. That's the only difference. If your lordship finds that the initiation power is preserved in my model, I mean, in case it's just loud thinking, because there's nothing so clear here. In case the initiation power, which is clearly borne out by the language of 17A, I have no doubt that 17A language bears that out.
No
also.
problem. Yes.
It is not, I mean, your lordship can interpret differently, but it does not rule it out. If that power is borne out, then it is possible to harmonize that initiation power under 17A with the private complaint and public servant character through 156.3. It will require some obvious harmonization, but that's a possible view. Anyway, I leave that. I come to 38. Section, this is only an alternative argument in the sense that it's not, it's not dispositive either way of any of our cases. 17A places a public servant on a different footing and grants to such public extraordinary layer of protection. This extraordinary layer is set by our lordships, not by me, not by. The protection, the pre-investigation may not be as stringent as stage of sanction. I've already said.
That is by the coordinate bench.
Yeah, I mean,
Yes,
by
yes.
the court, not by, not a submission.
Yes.
Then 26.2 is neither as weak as Lalita nor as high as sanction.
Yes, that's
And
fine.
26.3, not be necessary to have incriminating material to show conclusively, but it's still necessary for credible information. Then while I'm trying to harmonize to the extent I can, while a microscopic examination or meticulous consideration may not be needed, cryptic orders will nevertheless fail to meet the requisite test. In this case, at para 51, the court concluded a clear opinion had been found by the investigating officer that he suspected the commission of an offence. Subsequently, on considering the material, the state government came to the same view. In the present case, certain important factors must be borne. Now I'm applying it here. There is no view at all found by the IO. Now, this is what I want. This is my problem. There should be, otherwise, the lordship is opening the floodgates. And my word friendly governor was not intended as a mark of insult. I'm talking of a constitutional lacuna. If this 27.1 is accepted by your lordships against me, it's my submission, but if it is accepted against me, then your lordship is allowing this friendly governor or a opposite political color state government. And whereas all these concepts of governor above politics and neutrality is now gone. Let's not live in fictions. Whereas we
Now-
have governors,
now,
we have got governors who are resigning from governorship and fighting elections.
So now to seek.
There is no such thing.
Correct. No, now if your submission is that the investigating officer only should seek sanction, approval from the hands of the competent authority, who is the investigating officer here to seek approval? There is no investigation now?
Then,
Not yet commenced?
No, that he will
Not
have
yet
right.
commenced?
That's a procedural matter. If somebody goes with a complaint, somebody
That's
will have to
what.
appoint him.
Somebody goes with the complaint.
Or-
There is no investigating officer to form an opinion and seek approval. Who will seek approval?
Complaint. Now, let me answer, my lords. First of all, your lordship will decide it in a true case. Your lordship will not be asked, as they are doing, to decide a
No,
hypothetical.
I am only.
Now, on the inquiry, no, what I'm
Yes.
doing, lordship will answer. There's a very clear answer to your lordship. The dates in this case give the answer. This man files on 18th July. And the governor,
No, 18 July, he registers a complaint.
then 25th additional.
No, that is not taken note of because I see
So-
the order.
So
For want of approval, he does not proceed further.
Then second is 25th of July, he files a further information to supplement the initial.
Yes.
Then 26th, he goes directly to governor in less than 7 days, 6 days. Now, the query my lord is putting in a case where there is no action. Maybe a writ will lie to create an action. You can't say, I go today, give him 3 days, and I go to the governor and bypass. 17A can be bypassed because that's the way to do it.
That wins.
But therefore, the escape route to your lordship's very valid question would be that if I try to defy and don't ever give anything. I have no inquiry officer, I have no policeman, I have nobody appointed. Well, the Lordship's writ court will settle in 2 minutes. But whereas here, these dates are important because you are actually bypassing the system of 17A. 3 dates. 18th, he lodged a complaint with the Lokayukt police. 25th, he filed a supplementary information. 26th, he went to the governor. Where will the poor police officer will not function so fast? Even if they have to function. Yes. If I am deliberately not functioning, if I am a police officer,
No.
if I am the state,
First,
etc.
154.1 was 3 days before they going to the governor or registering the private complaint? No. When was the first complaint registered?
It is 18th.
18 June,
No, July.
18 July, first complaint.
Yes. 1 minute. 18th July is the first complaint by Mr. Abraham. Yes.
All right.
And he never approached the court saying that Mr. Policeman, you are sleeping. Mr. State Government, you are doing nothing. Please give a mandamus. Maharaj, if this is so, what prevents your Lordship from having hundreds of people coming and saying, 70 day be damned, I am going straight to the governor? That's a point to be considered, Maharaj. Your Lordship will
And
then
when
have...
did you go to the next higher authority? 12/8. Huh? 5/7, sir. 5/8. And before that, you had already sought.
He closed the doors. Actually, Maharaj, if your Lordship investigates a very important question more, he then has power to go to the court. Not to your Lordship, writ court. He can go under 154(3) to the SP.
No, that's what I'm asking. 154, 1 jurisdictional police, no action. 154(3) SP, no action. 200 magistrate.
No, I am going further. Writ court will give it for the asking.
And that also, a mandamus to register the complaint.
But you do nothing. You come on 18th, you go home on the 26th and say, look, I am bypassed. Thereafter, Maharaj, nobody is going to touch it. You gone to the highest officer in the state, Maharaj.
All right, yes.
So these harm. Now, Maharaj, just look at the reverse for a minute. Just look at the reverse. This is all right. You don't have an inquiry officer. You did this. Look at the reverse. Is your Lordship not being asked to accept a gigantic principle, subversive of the discipline of law, that Maharaj, this 17A, what is left in it if everybody is going to the governor first? That's my reverse question.
Everybody, why will they go to the governor? Governor is the competent authority only to a few, not to everybody.
No, for any case, Maharaj, it is not at nobody's case that 17A is not required.
17 is required. Yes.
Now the question is that in every public servant case,
To the competent authority.
no, governor oblique competent authority, obviously, governor competent.
Yes.
Point is, where does the role of the police officer then remain?
After the registration of the crime.
So that's the Malas, that's the
That's
debate.
where we'll
That's
have
the
to
debate.
answer.
That's the debate.
Yes.
That's the debate. Then Malas, 27.1. In this case, directly approached, 27.2. The governor not concurred, took a different view and passed a cryptic order. Then Malas, come to page 40. This Malas I have covered now.
Yes.
Police officer is fully covered
Yes.
in the debate which your
No,
Lordship
this
just-
argument is over now. Yes.
And then Malas, your Lordship's judgment is also cited.
Yes.
Now Malas, para 29 Malas is really a para about this act. It's a point I'm keeping alive. I'm not Malas.
Yes.
It's a point I've fully said there. Not by any remote stretch shown to be part of the discharge of my official duties. That's the
That is, now we have come to the crux.
So therefore, Malas, Section 17 grants protection from decisions taken or recommendations made in the discharge of their official duties. All relevant timelines and record. Now, Malas, this is not by itself the crux. It is the crux because in this case, you have shown me nothing as to how I have been involved in the discharge, where this is. That is why it's a crux. That is important to remember.
Yes.
My Lord has rightly used the word crux because you have to show that I as a minister, I as a public servant, I as the chairman of a department, I as the file signer, I as the file mover, I as the recommendee, I as the statutory compulsory persona designata, something, nothing. But your discharge of official duties is because you are a public servant. So the discharge is as big as the universe, the entire universe. Now let's kindly see. Come to 29.2. The official capacity of the petitioner at various junctures enabled him to assist in fabricating record. Now, is this possible? Just kindly see this. This is being told to your Lordship's brothers. In pleadings, is this the way to get sanction? And of course, none of this is dealt with. I would have liked the governor to say, I grant sanction of 1 and 2, but I call this bunkum. I reject it. He can still grant against me. See this, fellows. Various junctures assist in fabricating records. Your lordship will not work on adjectives like this. Next, recommendation or decision is made by a public servant not directly or reasonably connected with the official. He is not entitled to protection. Third, it is not the official duty to facilitate the fabrication of fake record. Well, some comma, full stop, some sign. Some collusion, some meeting in a smoke-filled, dark-filled room, doing something, well, your lordship doesn't. And this is very easy to destabilize. Anybody will take a pot shot. The petitioner cannot seek or obtain shelter under the aforesaid statutory provision as the offences alleged are not in the. This is, I'm reading his reply.
Yes.
Consequently, contends the prior approval does not apply at all. Then take your chance. Take your chance. You are the one who went to the governor. You are the one who's got all this thing going. And now you are pleading this also. And you are pleading this on one of those amazing facts of fabrication of records. Not a word, not a single comma, full stop, remotely. Then, page 44. It is pertinent to note that since the allegation against the named accused are not in relation to any action taken or recommendation made or other name, there is no requirement of prior permission or approval. Well, this is amazing. It's extraordinary. Now, there is no answer to say that if this is so, Mr. Singh, you can be prosecuted without sanction. It is for him to take his chance, not for me. I'm only coming against what he did. I have started nothing myself. This categorical statement is not a concession. Mark 29.4 is my conclusion. And if this is true, then it's also apart from anything else, a wastage of public money and public time. If this is so, in addition, I don't know whether there's an offense of public wastage of public time. There's no offense like that. But this categorical statement is not a concession granted by the respondent, but an admission that the fundamental requirements of 17A with regard to recommendation made or decisions taken is not made out in the present case. Therefore, expatiate the impugned order. In that case, the sanction goes on this ground. 17A explicit, and I'm sorry to repeat, this para 29.2 is verbatim reproduction of his pleadings.
Yes.
No note, nothing, pleadings. So your lordship is obliged to rely upon it. I am obliged to rely upon it. The court is obliged to rely upon it. It's pain of perjury. It's on pain of perjury. Section 17A explicitly grants protection concerning inquiries that are to be conducted solely by a police officer. The clear implication or necessary corollary is that only a police officer has the authority to seek prior approval to lift the bar. This process, much like registering an FIR under 154, 156 or 173, requires the police officer to exercise independent application of mind. This application of mind leading to a further action is the sole and exclusive jurisdiction of the police officer, and no one else can replace him. Criminal jurisprudence is deliberately limited the involvement of private parties, ensuring minimal interference of complainant in order to protect the accused's right to a fair prosecution. It is only through recent judgments by the court that the complainants have been given a limited role. This is important, Malas. Complainants have no role except to the extent your lordship permits them in ABCD cases. This limited role is designed to uphold the integrity of the criminal. Why do your lordship not give this, Malas? Because you just can't say that you can kickstart the whole thing in motion. Allowing private individuals, 45, to move the competent authority for prior approval would create an untenable situation where the police officer's authority to apply his mind and determine whether a case merits such approval would be undermined. This is, Malas, the core larger legal question lordship should, Malas. In this case, these dates I have done, but 29.6 I have done, Malas.
Yes.
18th, 25th and Malas. 18th, 25th and 26th. These are the three dates in 29.6. Then, Malas, the SOP.
When was the approvals, before the private complaint, when was the private complaint registered?
13.8 is the private complaint.
Private complaint.
13th of August.
Right. 18.7. No, 18.7 is the first complaint.
The first complaint. 25.7 is the supplementary.
18.7 first complaint.
25.7 supplementary information.
Yes.
26.7 approaches the governor directly. Can you note one moment? Same day he issues show cause. 26.7.
Fine, that is argued. Yes.
And then Malas goes on.
That is
13.8. 13.8 is the
That is
register.
because Lalit Kumari says when a cognizable offense is brought before the court, brought before the police, crime should be registered with, everything should be over in 1 week and crime should be registered. If it is not registered in 1 week, next rung. There, if it is not registered in 1 week, next rung, that is 200 before the magistrate.
Well, then what?
That's what, no, that is
My lord,
the
absolutely
purport of Lalit Kumari.
My lord is absolutely right. What happened to Lalit Kumari when Sashikala Jolie was pending for 24 years? 24 months?
That is approval,
Something-
not welcome.
No, but Malas, I mean, it's the same.
No,
thing.
that parity we'll see what has happened later.
No,
Because
that's
that is something that has happened now during the pendency of this petition.
yes. No, that is the judgment has come. I mean, the
No,
order
no,
has
the
come.
order has come now. It was pending 21.
Pending,
Yes.
pending. Then, Malas,
I'm surprised that is approval or sanction is not
the
even
Lordship said so,
clear.
we checked up. We were also
Yes,
surprised.
it is
17,
approval
18.
only. Yes.
Now, Malas, last, I'm just ending, Malas. I want to just cover some facts and then I'll
Yes, yes.
try and end. Lordship, give me a few extra minutes, Malas. I want to.
No,
finish.
take your time. sir.
Malas, 218 is page 46. I say it is virtually.
1-8 stage, I think, has not
virtually
yet come.
conceded. No, just read this one para only. It is virtually conceded. The Honorable Governor has, apart from granting prior approval, also proceeded to grant sanction. Your Lordship is right, but that's not what the Governor thinks. The Governor says, I am granting sanction. It's written there, Your Lordship has seen that. During the course of the submission.
218 is what is 197 under the CRPC.
Correct, 190. During the
So-
course of submissions, the learned senior counsel of R2
Hmm.
made a categorical statement that the impugned order is not a sanction order of 218 and must be read only as an order of prior approval. Your Lordship will record
So
this
you
because
need
that
not,
takes,
you need not labor on that.
provided it is recorded. What happens is ambush points are taken. Either
No, no.
side appeals and we say,
Yes.
no, this is not decided by the judge.
No,
But why will the judge decide this? You have conceded it.
No, that is in the written submission also.
Yes, also.
Yes.
Therefore, Your Lordship may just take that note. I am not arguing for that reason only.
Yes, yes.
Otherwise, Maharaj, I am demonstrating completely that this is wrong. But anyway, he's saying that it is to be treated, this itself is non-application of mind, Maharaj. To start treating 218s or 197s as 17A is itself non-application of
No,
mind.
no,
But
it's,
leave that aside.
they operate in a
Leave that
different.
aside. Now, Maharaj,
Because 197 is after investigation.
yes. Now, Maharaj, no, he's saying treat it now as a 17A order, prior approval order. That's all.
Yes, yes.
Now, Maharaj, page 47 is very important. Well, it's 3 or 2 very serious errors of law were made and then the facts. Natural justice was brushed aside on the simple point. Notice was given to me and so what, I didn't send you the other 2 complaints. I'm not required to give notice at all. That's the very, very far-reaching. So first argument, I gave you notice, but I'm not required to give you notice. But since I'm not required to give you notice, I'm not required to send you the other 2 complaints. So my own definition of natural justice applies. And third, so what does it matter, Mr. Singh? There is no prejudice to you. Let's get on with the matter. All these 3 things are answered by the Supreme Court evocatively, and my learned friends have completely misrepresented the law on this point. The law is totally different. Just come on prejudice for us first. Dharampal, page 48. From the above discussion, it becomes clear the opportunity to provide hearing before making any decision was considered to be a basic requirement in the court proceeding. Later on, this is all very common, so we ignore it. The more common, the more important is to underline it. Later on, this principle applied to other quasi-judicial authorities, even in administrative, before taking a decision, hearing is necessary. Boldface, Krepak, etc. Now just see what he says, Balas. So far, so good. However, an important question posed by Saurabhji is as to whether it is open to the authority, which is to take a decision, to dispense with the requirement of principle of natural justice on the ground that affording an opportunity will not make any difference.
No, that's not.
To put it differently, can the administrative authority
No, it
dispense?
can't be said. Or even if I give you notice, what will you say? That cannot be the reason.
That's
at all.
I was not
That
required to
can't
give
be.
you. Even if I gave you, I'd have the same result. No prejudice would happen. These are the angles of the same argument.
But here, he only extracts one paragraph in the order saying that there are 2 other complaints. No contents of that complaint is noticed.
That's my grievance. That's my grievance. Because he has already sent me notice. So now I'm dealing with 3 points. One, if you elect to send me notice, you are stopped from arguing that no notice is required. That's proposition 1. You're in administrative law.
Yes.
If you elect, I did not elect, you elected. You elected to send me, then you cannot say that now notice is not necessary. Second, if you elect to send me and do not send anything else, then you cannot take the plea that even if I had heard you, nothing else would have happened. They are the 2 main propositions.
All right.
Now we'll just come to 31.3.1 at page 49 bottom.
Yes.
49 bottom. The request for prior approval was received by the governor on the same, and third, I'm very sorry, third is the most important. He gave a detailed half-day hearing to the complainant. It can't be brushed aside by saying criminal law. I can hear whom I like. He heard the criminal law complainant, he gave me notice, then he did not give me the notice for the other two, and then said no prejudice. That's the fourth, let's put them all together, and whatever the conclusion is. The request for prior approval received by the governor on the same day a detailed hearing is granted to the person seeking. Same day, the governor further finds a prima facie view on this meeting alone and proceeds to issue show cause. Such view was formed despite the fact that documentation was mostly in Kannada. The detailed setup of the governor is obviously not Kannada. So very detailed. 200 pages. I have seen, my learned friend has seen, is all Kannada. Obviously, he didn't learn Kannada overnight.
He says prima facie case filed against him.
Prima facie case. No, these are important. If you are doing this application of mind,
Yes.
what when a mind can't apply in a language you don't understand? What application of mind in a language you don't understand? This? The detailed set of documents provided by the third is in Kannada, application by fourth is in Kannada, fifth respondent is not even on file. The Honorable Governor, as can be seen from the response to the RTI, admits that he needed an English translation. He writes the file to proceed with the other application for prior approval.
Aid and advice of other officers.
Yes, for the others. But in the present case, Kannada seems to be the chosen language. This is in the other cases. Here, on the same day, on 26th July, he proceeds.
Yes.
In the present case, English translations were done by the governor's office is not borne out from the records. Whereas in the other cases, investigating agencies are directed to file translations. There's an order noting. Now, this is the direct proof. Well, this matter, this particular order must be set aside. Whatever order he has to pass, etc., is a different matter. The Honorable Governor, on the basis of petition accompanied by more than 100 pages in Kannada, come to the conclusion the allegation serious nature and prima facie need action. Also notices that complaint is filed to the Lokayukt police. It is rather surprising and ironical that the Honorable Governor, unable to read and decipher Kannada, is also able to digest documents of hundreds of pages, etc., and issues notice immediately. There is undue and inexplicable haste. This is not a facetious thing. It all adds up in the overall. It's not just a light game that I'm saying he doesn't know Kannada. That's not the point. He's not expected to know Kannada. I'm not suggesting a lordship. In fact, in the old days, there used to be a bar that you're not, even today is a bar. You can't be from the same state if you're a governor. The application for prior approval.
It's all right. How can you interfere? Yes, I am aware of that.
The application for prior approval sanction is received by the Honorable Governor. Addendum is on 26th. Addendum is also received same day. Let us kindly see page 51. Opportunity of detailed hearing of 3 hours is provided. And by 10:30 on the same day in the night, 10:30 p.m., a show causes notice issued. A process in such a manner by one of the highest constitutional authority against another highest constitutional functionary is unheard of. I'm saying this well with a sense of responsibility. Such application, the Raj Bhavan would on the same day reach the governor, and then hearing to a private party takes place on the same day, a show cause. This is all Article 14, etc. And your lordship will see the totality of the earlier arguments also. Then, Malads, 31.3.4.1 is page 52. Sashikala Jole, all the dates are given to your lordships. At one place, at page 52. Murugesh Nirani is the other case.
That's also pending?
Returned on
Returned.
28/8. All is happening after this case has started. He's either returning or rejecting. Approval is only my case. Now you have to explain the delay. Well, it happens even in the judiciary. Sometimes after 2 years, the matter is put again for clarification. So here, after 2 years, in Nirani's case, he sends it for clarification on 28th of August. Then, same thing about H.D. Kumaraswamy, returned to the requesting authority. Then, it is very clear the dates are all after the hearing of this matter has started or after this matter has become a dispute. Not hearing started, but dispute. Then, application of 13th of May submitted for sanction was returned by the governor in June 2024. On 21/8, investigation replied. On 28/8, the application was returned for English translation. Well, by the way, each of these, that is, page 52, all the cases except Sashikala, page 53, all the cases are returned after they come back from the clarification, further returned for translation. Well, I hope I'm clear. Take, for example, 53. My case, the same day, the night, Same thing. Now, let us see this ground. This is very, very important, 53. In Sashikala, he does exactly what I've been laboring the whole day today. He did not do in my case. That is
Rejection.
quoted. It is quoted once. He has given, I'm not saying it's right. I'm not saying who will challenge, not challenge, what your lordship will decide. But is it anything your lordship found? Just glance at it, Bharat. Any word similar in my case? Is in the chief secretary in his report says on 23rd of March, no proposal for grant of any tender. In such circumstance, the question of asking for a bribe does not arise. This is what I wanted, Maras. This is the meaning. Your lordship is asking me what the review judicial. This is judicial review. We don't need.
Wait, sir. I'll get back to you. Wait. Yes.
In order to attract the provision of 730, there must be a receipt for the bribe amount. The mere statement one was paid 25 lakhs, paid whether he received the amount is not clearly disclosed. For sanction on inquiry necessary to prove the demand of illegal gratification. So, Malas, he's doing the ingredients of POCA. He's writing. And then, Malas, he says, hence I find now.
20.
Then, Malas, para. 20 is red. It's already red. Then, Malas, 55. I will skip till 59 because I want to take a lordship's 10 minutes on that dates. 55 to 59 are largely dates, Malas. Your lordship may just give me and then I'll come back to it because the matter ends at 62, but just come to 63. Just come to 63.
List
Now,
of dates.
Yeah, they just note on the side.
Yes.
All these documents are in the writ or filed by them. Number two, I have not going into it. My learned friends have gone into it meticulously in the arguments. Half the argument, 3/4 of the argument, Mr. Maninder Singh was on these facts. 3/4 and others. But I want to now show the true facts. And what I've done in the table is document 1, document 2 I put on the left side. Lordship's got 63.
Yes. Yes.
I made one compilation of all. They're already there in the writ or elsewhere. There are 4 new documents. One is Shashikala Jole, which is not a new document, subsequent development. One is the plan, which is all are mentioned. Apart from Jole, each and every one is mentioned both in my petition and in the cabinet sanction or denial of sanction.
All right.
All mentioned. Now just see the startling consequences very quickly. Malas, 92, your lordship has a notification. Then Malas, the old fellow, the earlier owner is Malas Devaraju in item 4. When I say 4, I mean document 4. Malas.
So, Devaraj is the owner.
Then owner.
Was not there a relinquishment in favor of one Cheluraya or something? Mailaraya. How did Devaraj become the owner?
No. That is much.
1935.
Subsequent to that, a release deed in favor of Devaraju.
Where is the release deed in
Yes,
favor
yes.
of Devaraj?
Give me the page. Is it on record? It is mentioned. Where is the and the averment in the writ? And the averment in the writ.
Now, since you are replying on facts,
No, it's very
it
important.
should be clear.
Very important. Very important.
It's 10th of April, 1993.
Yes, Rangnath.
10/4/93.
ನೀವು ಹಾಕಿರೋದ್ರಲ್ಲಿ there is one relinquishment deed in favor of one Mailaraya or something. Yes.
Now,
1935. It was 1935.
No, let us see. The date of the one thing say one thing.
Mainari was 1935 from the same family.
What's the date?
10/4/93.
10/4/93 is Malas in the documents file. Give the file to my lord. Page 11.
We gave it in the morning.
Page 11.
11
Oh,
to
it is release the land in favor of Devaraj, is it?
Yes.
Yes. This is we are talking of 93.
Huh. Which is that I have not seen this document at all.
It is.
Where is it in the original document?
Yes,
Right.
Rangnath, you have not produced this? No, which is this 10/4/93 document?
No, this is produced now, Malas. It's produced.
Now it's not a part of the record. No, nim record allu hakilva adu.
It is recorded in the writ. It is recorded in the cabinet thing, but document is this. Cabinet,
Where is that document?
this one? Page
It
11.
is given in the morning.
That bunch we given once.
In the morning.
All of it is in the writ or the cabinet decision. This bunch. Kindly give the bunch. No,
All right.
no, morning. Just show the bunch.
ಬೆಳಿಗ್ಗೆ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
This document mentions in the writ.
It is not in the.
It is mentioned in both Malas, my reply to the governor and in the cabinet decision.
Yes.
Now, Malas, kindly come to. I obviously can't read it.
No, that
And
document number 3.
4, I think.
4 is it?
4. 4.
No, in
Three,
this
three,
you
three.
say document number 3, 10/4/1993.
Bhautik khate.
Document 3.
Bhautik khata.
Well, just for fun, we have made serial number
Inputting the
4.
widow Mailara.
Foolish, why did you make
It's all right. ಭೌತಿಕ ಖಾತಾ ಒಬ್ರಿಗೆ ಹೆಂಗ್ ಹೋಗುತ್ತೆ?
Bhauti Ninga is no more.
ಲಿಂಗ ಇಸ್ ನೋ ಮೋರ್ ನಿಜ. 3 ಮಕ್ಕಳು. ಭೌತಿಕ ಖಾತಾ ಆದ್ರೆ ಅದು ಒಬ್ರಿಗೆ ಹೆಂಗ್ ಹೋಗುತ್ತೆ?
ಕೊಡ್ತಾರೆ.
memo?
Surviving 3 brothers.
Let's see. Yes.
Right,
All right.
fellas?
Yes.
Now, kindly go ahead. Then, Malas, this Devaraju makes an application in document number 4 for Malas deletion.
Yes.
Then, Malas, a resolution is passed in. Well, look at this person who is trying to grab all this and is so corrupt. We're talking of 93, 97. That itself, Malas, and a person comes today. I'll read that para about the antecedents of those who have come now. Keep that para ready. Keep it out. Document 5 passes a resolution that they can be excluded in 97. Then, Malas, notification is issued. Now the Commissioner MUDA recommends for release.
Yes.
General award is passed in document 8. Denotification is again recommended to 9. It was made to sound like a huge conspiracy that there is no denotification at all. These are all Malas.
No, denotification is there.
Assume it is wrong. This is a government process going on. It is not something which I am the minister in charge or is done for me or not for others. Then Malas 10. Denotification is issued under 48. The Rosh was specifically told, where is 48? This is no 48. This is all false 48. I was there, Malas. It was 48 was just brushed aside as some kind of thing. What is this document, Malas? Item 10, page 47 to 51 in the writ. Then Malas, approved layout plan is important. This is mentioned again in my and Malas the cabinet, but I produced it at page 52. How do you approve a plan, Malas, by saying denotified? Can a lordship have an approved plan of denotification without it actually happening? Somebody will go for forgery, Malas. And forgery would have happened, Malas, in 98. We are in 2024. Then Malas, very irresponsible and extremely rhetorical and hot-blooded accusations were made, making the whole thing look like a scam for 23 years. Ignoring all this, and people who knew so much to say also had all these documents. Those who argue with all this vehemence are deemed to have all these documents. You can't argue, so I did not know. If you did not know, you jolly well be responsible and don't raise it in so irresponsible a manner at such a high pitch. Then verse 12. Notification does not show the lands in question. Now this is because it's denotified. This is the reverse thing. I'm showing an omission in item 12. An omission. Now you can say that all the documents for 25 years have been forged. Thankfully, you have not said so yet.
No, that's not.
You have
there.
not thankfully till now said so. Then Malas, personal award is passed in 13. Now it is possible, Malas, that despite this, I'm such a superhuman human being. But this is not a ground automatically without adverting to a single fact to grant a sanction. This is not the kind of case a lordship, Malas, has cases where a lordship has. What has happened in Malas, the precedents have muddied the field because you have corrupt people. You have people with the same day, same this thing and all. Fast. This is not that kind of case. This is proceeding at, if at all, a inordinately slow pace in my view. In my view, a very slow pace. 13, personal award. 14, illegal allotment of sites on paper. This is a reality. Please check up. And Malas, at 61 to 71, it is found Mr. Abraham's application. Mr. Abraham's application. And they have argued and he has argued such vehemence.
No, allotment of sites is not on paper. It has actually happened.
It
To
is on
the
paper also.
allottees of the layout, it has actually happened. Yes, Raghunath. It has actually happened. Ah.
Paper.
Yes.
Malas, may I say,
Yes.
de facto 100%. 100% de facto. MUDA is dealing with it. Nothing on the paper will happen. Nothing on the ground will happen without the paper, Malas.
True.
It can't be that in the air. This is a MUDA authority. Document 14 is found, Malas, 61 to 71. Lordship may see. I put the page. What else can I do, Malas?
All right.
But this is not a figment of imagination. And none of this is dealt with by the governor. First time a sale deed happens is 2004. So Lordship will draw a line
Yes,
here.
first sale
From
date is
97
2004.
I mean, sale deed relevant to not him, but his brother-in-law.
It is
I mean, not him, but his brother-in-law. I'm drawing a line still. This is Malas from 92, 93, and Lordship is stopping it 2004. This is a whole decade. Then Malas, conversion of lands is applied. This is applied in 2005. And Malas, just see the next date between 16 and 17.
5 years.
Such a mad rush because he's been in politics all along, Malas. He's been either an MLA or he's been a deputy chief minister or a minister. He became a minister in the 80s. Such a mad rush, man. He must be madman, Malas, that he's taken 5 years to have a gift deed to his wife. These are Lordships reads the totality, the holistic. This is not some kind of a scam, Malas, where the man is desperately trying to grab something. He's taking 5 years from 16 to 17. Then Malas, 18. This lady Malas requests to allot alternate land. Now, it is not the only lady who gets it. It is not the only case of encroachment. It is not the only time it has happened. It just happens that I am the chief minister's wife also. Then Malas, 19. Proceedings of the meeting where the application is discussed and decided as follows. This is Malas, 90 to 94. This, Lordship, just note that. That thing your Lordship asked me. Just note on the side.
Yes.
My son is officially ex officio, Malas, all MLAs. I've checked.
Yes, all of it.
So
Not
that is
only,
one.
I'm
No,
not saying that it's only
I-
yours.
My Lord asked a neutral question. I'm giving the facts only. I'm also giving a neutral.
As an ex officio member of MUDA, being
All
an
MLAs.
MLA of the constituency, you had participated in those deliberations which decided to allot alternate sites. Is
Number
the
two, no, but there's something more interesting. Malas. The minutes of the resolution of that meeting are fascinating. They are in the relevant, the same volume, page 96. All the people, including MLAs who participated,
Yes.
contributed.
Yes.
This man did not say a word.
It's all right.
No,
Yes.
I'm just saying there's no participation.
Yes,
He's sitting,
yes.
he's attending. There's no participation in decision making. None. None.
I'm not-
And this complaint is against me.
No, the complaint is against you.
Yes.
That's all right.
And fourthly, that person, my son, is not made a accused. Now, Malas, if it is private,
Yes, all right.
right. Now, Malas, very well. Now, Malas, today, if Malas, I am to be culpable because of this one incident of 19, which is happening in 17, when Malas, this event happens, then Malas, your Lordship will see the totality also. That's the point.
No, their allegation is the beneficiary is the roof.
I understand, Malas. I mean, this is the allegation is much
The
more.
roof of the chief
This
minister.
son came now, Malas. The allegation is that this is happening from last, all the decisions, this denotification is the allegation. The encroachment is the allegation. No son, no father, nothing but it's the allegation. This is only the Malas consequential decision which is coming up now. That act has happened.
It's an
earlier.
allegation, not a conclusion. It's an allegation.
Now, Malas, my first point is, have you dealt with it anywhere in your order, Mr. Governor?
That will, yes.
Have you then shown that is there any connection with me in a manner which can be credible? Have you addressed it? There is a whole para which addresses it in the cabinet decision.
Yes.
Have you then dealt with that para and said this is wrong because of 1, 2, 3, 4?
That I will answer.
This is the. And then, Malas, then of course, willingness given.
What?
Now come to Malas, document number 23. No,
Can I just-
sorry, before that.
No,
No.
it's- no.
20 onwards, Malas.
Speech impact,
20,
everything
20
is there.
onwards is very important. Just draw second line at 20. That is 14, 11, 19. I am in the opposition. But should I put that line there? Item 20.
Oh, yes.
Now, then, Malas, the principal government department writes to MUDA to take a decision at their level. Proceedings of the meeting of MUDA where it decided to give 50% of developed area as compensation. Willingness given by not me, but by Malas, 14 or 15 other people across the state, or where not across the state, in the relevant areas. Then Malas, relinquishment deed, etc., the last 4 dates. Now, Malas, the last part is come to Malas, the submissions at page 55. Come to 55, the submission, I am done, Malas. So, Malas, there has to be a proportionality for this one meeting and most of the time outside of the power. If you are going to go that far, then Malas, totality doesn't justify, you have not dealt with the administrative law aspects.
You told me to remind about RT's antecedents.
Then Malas, come to para 32 of my note, page 55.
55.
Yes. So 32 and 33 gives the same list of dates. All the way, Malas, to the end of 56. Come to 57 top. The denotification is not specific to the subject lands, extended to other lands.
No, it is, denotification is not only this land, it is something else. A denotification happens to the adjacent land, that is also there on record.
19 is what I've said, Malos, at page 57, 19
What is
examples.
this survey number denotified?
464.
462. 46.
462 now.
462.
One person.
464.
462 or 464?
462 and 464.
460.
19 in the problem.
Now 19 other is important, Malos, at page 57.
No, all that is there.
Yes. Then, Malas, just note that these are impressions given to your lordship in the prejudice part of the argument. Therefore, I'm just very quickly clearing them. Now, Malas, 33.3.1. The notification does not, under 16.2, does not cover the lands in question, and the lands were therefore excluded. This notification is 33.3.1, Malas, of my note. No Panchnama, no inquest report, no memorandum, no sufficient documentation as required under Indore Development Authority regarding taking over of possession. Your lordship is told taking over of possession. Then, Malas, now this para 33.5 I have put in boldface. And you just see it for a minute. Allegations questioning title are based on suppression of the crucial family settlement. Now, Malas, you are questioning my title. Inside my family, there is no dispute. It's a family settlement at para 33.5. Number is given. Register is given. There is no jhagda, but Malas, somebody else is
No,
questioning.
that's not the submission also.
Then, Malas, that other writ, Malas, is identical for this reason. That's very important, Malas, to remove that impression. Where, Malas, the matter was not proceeded with and the land was released.
Which one, sir?
Other writ was said that we have suppressed the writ number and all that.
Sundarama.
Sundarama's case. Sundarama's case is only cited for the point that another case where actually acquisition was not
Oh,
continued.
that Justice Bhajantri's order.
Yes.
Yes.
It is not continued. So also in my case, acquisition is
Yes,
not
one
continued.
second.
Just 5 minutes more.
Yes, one.
So 61 is very important. 50-50 benefit taken by hundreds of people. It is not just me who's got it. 61, we have made a chart.
Yes, sir.
Now, Malas, that other matter, just see 61 and I'm done in 2 minutes, Malas. 61 is a list. This is important. I put a chart.
Yes. And
This
there-
MUDA, look at what it did for an overall policy, Malas. Look at the number of sites, Malas. 50-50 ratio. This can't be, Malas, any kind of an individual case, Malas. Then sanctioned without land acquisition, 570. First one is without compensation, 358. Without acquisition, 570.
Yes.
Then prior to the date, 99. After the date of 5/1/22, 835. This is completely, well, to particularize it as if some kind of conspiracy by an interested party is wrong. This is all Karnataka thing. Then, well, Sundarama is important because, just note one thing, 33.8.3, which is at page 61. 61.
There is no distinction between the case.
That was what was thought to be said. There is a vital distinction. There is none. Where land acquisition is not initiated, and a case where land acquisition is initiated, but the land is later denotified. That was the example being given. We have given an analogy. We are not saying we are that case. We were saying that land acquisition was in the process, was not initiated then. Mine was the case initiated but withdrawn. So the result is the same. There is no distinction. Lastly, just note my writ para, page 31. Page 31. This also
of the writ petition? No, of this.
31, yes, in
Sub-
the main writ petition.
Yes, it's main date petition.
Main writ petition. 1, 2, 3, 5, 6.
Krishna, you said nip it in the bud.
Yes. Page?
Well, it is also important for such matters. It is not that it's a rule of law, but the sanctioning authority gets a feel of the case. It is not that everybody on Malas will come and start doing this. Frivolous, vexatious, or dubious antecedent people should never be encouraged because this is a much larger repercussion. You are protecting public servant anyway. Here you are protecting a public servant against dubious people of dubious antecedents with frivolous, vexatious objectives.
What's dubious?
Yeah, come, 31. 31.
No, who's dubious here?
This particular person was 631.
Page 31.
Reading the paragraphs.
No, 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 you just say उसके बाद में-
The credit, no.
Oh, antecedents of respond number 3.
This is one example. Let me. Mr. Abraham is a crucial factor. He is a habitual litigant, well-documented history of engaging in blackmail, extortion, and the misuse of legal processes.
No, I would put it this way. Yes, it may be. A whistleblower will always face these problems.
Provided he doesn't have, a whistleblower need not have an antecedent thing. This is not
No,
this
any
25 no.
any whistleblower will always face this problem.
Correct. Will the Supreme Court impose 25 lakhs cost on a there can be whistleblowers
him-
without this?
on
Next
him-
sentence, please
All
read,
right,
Manoj.
yes.
It's not a,
Yes.
he is a habitual, I have put words here, Manoj, advisedly. He is habitual litigant with a well-documented history of engaging in blackmail, extortion, and misuse. His conduct has been repeatedly condemned by various courts. Supreme Court imposed a cost of 25 lakhs in SLP. 25 lakhs is not given in 2017 in even 1 or 2 cases for abusing PIL. In addition to the history of vexatious, respondent has been involved in criminal activity. But a lordship is a judge who takes a holistic view. Ultimately, judges have to take holistic view. FIR registered in 2023 for offences including, can't you have whistleblower without all this, police? Extortion, outraging the modesty of a woman, criminal
Outrage of
intimidation under sections 384, 506. Complaint filed by Sudha, a government official, alleges that Abraham attempted to blackmail and
384 is
intimidate.
not outraging modesty of a woman.
What is the
Oh, that
section?
matter. 384 is extortion.
384 is extortion.
All right, yes.
The complaint filed by Sudha, government official, attempted to blackmail. These serious
Sir,
criminal antecedents
if-
evident that he
sir,
lacks.
If we can do this, if give me 5 minutes, I'll resume. Whatever it is, I'm going to complete this today.
I have in fact finished. Police.
Yes, sir. I'll get back in 5 minutes.
Certainly,
Yes.
certainly.
What?
Sorry?
He's going to conclude today. If you want to argue, you can argue with me.
Yeah. You have practically covered,
No,
I just
whatever you want to
take him
say.
through.
Yeah.
I'll take him through.